Ms. Braley, how are you? Great seeing you again. How have you been? Yes, sir. Thank you.
The Subcommittee on Commerce, Trade, and Consumer Protection will now come to order. The chair recognizes and himself for 5 minutes for the purposes of an opening statement, but before my 5 minutes begin, I just want to take a moment to welcome all those who are witnesses today and those who are in viewing this from the position of the gallery or those who are sitting in the audience today. And now the chair recognizes himself for 5 minutes for the purposes of opening statement. The focus of today's hearing is the Motor Vehicle Safety Act of 2010 draft legislation. 2 months ago, we assessed the National Highway Traffic Safety Administration's functionality and effectiveness. The unfortunate accident resulting from unintended acceleration revealed to us the need to modernize NHTSA. The laws were written in the 60s and 70s and do not reflect today's global marketplace. And I wanted to take a moment to commend Chairman Waxman for his leadership in drafting this important piece of legislation. There are 5 objectives that this legislation will attempt to address. It energizes the agency and equips it with the expertise and technology that is sorely needed to achieve its primary goal, while responding to today's rapidly advancing electronics technology that really is at the heart of all the new vehicles on America's highways. Secondly, it promotes safety and innovation by establishing tougher baseline of standards that better protect consumers. Thirdly, it enhances the enforcement mechanisms by increasing the agency's authority to remove vehicles from the road if these vehicles pose a serious imminent hazard and if its manufacturers did not on their own take the appropriate action. Next, it increases transparency and accountability. The concepts of transparency and accountability are a prerequisite for any effective policy regulation. And lastly, we reform the safety standards for consumers with this piece of legislation. We also protect our industries and the American worker by helping to save jobs, by allowing the industry and the American worker to continue to regain consumer confidence in their brands as they continue to build and sell cars and to generally help America's auto industry stay competitive in the global economy. This is what the proposed Motor Vehicle Safety Act of 2010 is attempting to do. We will get it done. Some in the public will question the need for new legislation to improve the safety and quality of vehicles. And I, for one, and I'm sure that other members of this subcommittee will join me, strongly disagree with those who take that kind of position. Despite the fact that I am sure that automakers are attempting to do all they can to win back consumers and improve the safety standards and equipment that's located and found in their vehicles, I think it's more reasonable to say that perhaps the horrific unintended acceleration incidents that have been well documented before the subcommittee and others might not have happened if we had had the appropriate regulations already on the books. And it's my firm belief that this legislation and the reforms that it mandates are long overdue. Simply put, it's time to act. And the time to act is now. Before I yield back the balance of my time, I want to thank the witnesses again for taking the time out of their schedule and to advise members of this subcommittee. The draft legislation that we're examining today is the result of a series of consultations with stakeholders from the consumer groups and also from manufacturers and also from the administration. We all have the same objective, which is to save lives, prevent injuries, and reduce risk through technology, education, improve safety standards, and through vigorous, robust enforcement. It's been a collective and constructive effort, and I'm looking forward to hearing from our witnesses again. Thank you, and with that, I yield back the balance of my time. And I recognize now the ranking member, Mr. Whitfield, for 5 minutes for the purposes of an opening statement.
Thank you very much, Mr. Chairman. This is our third hearing on NHTSA and auto safety issues, including an oversight subcommittee hearing into the Toyota recalls. And today we're going to hear testimony about the discussion draft for the Motor Vehicle Safety Act of 2010. And we look forward to that testimony. During those previous hearings, we learned that we now are in the safest period in automobile history. NHTSA's report for 2009 revealed the lowest fatality rate on record at 1.16 fatality per 100 million vehicle miles traveled. 30 years earlier, 1979, that number was 3.34 fatalities per 100 million vehicle miles traveled. We have more cars and more drivers on the road now than we did then. Today we have more than 255 million vehicles registered, and they travel over 2.9 trillion miles per year. 30 years ago we had 157 million vehicles registered, traveling 1.5 trillion miles per year. These are impressive statistics, and it speaks volumes about not only the job that NHTSA has done, but it also speaks to the innovation of automobile manufacturers. And we also know that 90% of all accidents are caused by human error. Now today we are looking at this draft, and this draft requires 7 specific safety mandates on manufacturers. It increases penalties exponentially. It expands the reporting data manufacturers must turn over to NHTSA without confidentiality protections. And the thing that is most troublesome about this is that this is being proposed without taking into account what industry is already doing, what safety reviews are currently underway, and most significantly, whether this will result in any real safety benefit that saves lives. As a matter of fact, I don't think that we really even know the cause of the Toyota acceleration problem. All of us want our cars to be safer. We want regulators to have the appropriate tools to be an effective regulator. And Mr. Strickland testified in his last appearance before us that he had the necessary expertise to deal with this issue. And so I'm very much concerned about the breadth of this bill, the width of this bill, the mandates in this bill. I'm particularly concerned about the unilateral authority for the administrator to stop production, sale, distribution, or even importation with no time limits. And I also think there is a lack of due process for manufacturers that may be hit with one of these mandatory stop orders. So I look forward to the testimony today. We have a lot of unanswered questions. I know this will be a productive hearing. And I might just also say another part of this bill that I'm very much concerned about is that it gives authority to bring fines of up to $250 million against corporate executives for data that they submit to NHTSA. So we need to explore this closely, and I'm confident that at the end of this hearing, at the end of this process, we will come up with a system that will improve highway safety and will be productive for the American people. Thank you.
Thank you. The chair now recognizes the chairman emeritus of the full committee, the dean of the House, my friend from Michigan, Mr. Dingle, for 5 minutes for the purposes of opening statement.
Mr. Chairman, I will waive my opening statement. It's an excellent one, and I would urge everybody to read it. However, in the interest of the time of the committee, I would ask unanimous consent that it be inserted into the record, and I thank you for your courtesy and commend you for holding this hearing.
So ordered. Now the chair recognizes the gentleman from Michigan, Mr. Sarbanes, for 2 minutes for the purposes of opening statement.
Would that it were that way. Thank you, Mr. Chairman, for holding the hearing. Appreciate it very much. We look forward to the testimony today on what this legislation can offer to the National Highway Traffic and Safety Administration, both in terms of resources and in terms of extra authority. Of course, Americans will make reasonable assumptions that we're protecting them until an incident occurs, and then it points up some of the thin places in the oversight and regulation that we have, and we got to make sure that the agencies responsible for that oversight have the tools they need and have been given the charge that they deserve in order to provide that protection. I'm particularly interested in the testimony today that I hope will address the need or the issue of technology getting ahead of our oversight and how we have to keep up with that, and particularly the enhanced expertise when it comes to electronics within the department, because of course that's where all the cutting edge technology has taken the automobile fleet. So looking forward to the testimony. Appreciate the hearing, and I yield back my time.
The chair now recognizes the ranking member for the full committee, my friend from Texas, Mr. Martin, for 5 minutes for the purpose of the opening statement.
Thank the distinguished chairman. It's good news that you appear to want to move in a regularly order process on this piece of legislation. Those of us on the Republican side, at least myself, have just now seen it, or we saw it last week. So it's going to take us a while to digest it, Mr. Chairman. But you have shown that you want to use the subcommittee process in terms of hearings and markup before we go to full committee, and I sincerely appreciate that. There are some provisions in the proposed legislation that make sense. Making the NHTSA consumer complaint database more user-friendly is certainly something that I can support. I don't know that we have to have an act of Congress to make that happen, but I do support the concept. I don't have an objection to targeting resources to improve the agency's technical capability. It's obvious that in this day and age, we need our regulatory authorities to have as much technical competence as it's possible to have. Standardizing the brake override function is something that we certainly support. There are provisions in the proposed legislation that are troublesome. Ranking Subcommittee Member Whitfield mentioned some of those. I echo his concerns. I also echo, or at least state, that it appears this legislation in its current form would increase taxes. It would give the government some authority that I'm not sure it deserves, and some of the penalties, to me, seem like overkill. I don't believe this is the time, Mr. Chairman, to just pile on the automobile industry, or at least potentially pile on because they're facing tough times. On the issue of unintended acceleration, it's obvious that this is something that we still don't have an answer for with regards to what happened at Toyota. NHTSA has found, I understand, that Toyota has violated some of the reporting requirements of the TREAD Act by not submitting its reports of unintended acceleration in a timely manner. NHTSA as a consequence of that and other Toyota issues, has assessed Toyota with the largest civil penalty ever assessed by itself, a little over $16 million. 6 million Toyota cars have been recalled in the United States, and adjustments have been made. I'm not sure, Mr. Chairman, those adjustments really address the problem, but at least Toyota did make an attempt to make some of those adjustments. We still don't have at least if we do, I don't know it, a concrete explanation of what has actually happened and why it happened. We do have two separate panels that are looking into the issue. I'm prepared to wait for those expert studies to be presented to the committee before we begin the process of mandating new requirements that almost certainly will raise cost and may be of questionable safety benefit. Although if the evidence is conclusive that there is a real safety benefit, certainly myself and the other Republicans are going to be supportive of that. We have specific concerns with the draft legislation, Mr. Chairman. It mandates that all vehicles be equipped with a data event recorder. I have a new hybrid, Tahoe hybrid made in my congressional district in Arlington, Texas, and it has one of these recorders. I can see why you would want to have it, especially if your vehicle is in an accident or if you're accused of being at fault. One of the workers at the plant that gave me a test drive in my new vehicle said that he has one in his and was able to point out in an accident that he was involved in because of the data recorder that he was not at fault, and he had the data to back it up. So I certainly see that there's some value to these devices, but we also have some privacy concerns, and we want to make sure that people know that the data recorder is in their vehicle and how it's going to be used. As I said, the civil penalties in the draft legislation are excessive. Civil penalties of $5,000 per day are capped at $16.4 million. The draft legislation would raise that to $25,000 per violation and remove the cap. We certainly need to investigate that, Mr. Chairman. My time is almost expired, so I've got a few more things to say, but I'll put that in the record. Again, kudos to you and Chairman Waxman for agreeing to go through regular order. If Republicans are actually included in the drafting and in the witness process, if there is a need to legislate, I'm sure that Mr. Whitfield will be very interested in working with you and I with you and Mr. Waxman to try to do what's responsible. But thank you for holding this hearing.
Thank the gentleman for his comments. We've been joined by the chair of the full committee, Chairman Waxman. The chair will yield 5 minutes to Chairman Waxman.
Thank you very much, Mr. Chairman. I want to thank Chairman Rush for convening the hearing on this discussion draft of the Motor Vehicle Safety Act of 2010 and for being a co-author of the bill. This may be the most important vehicle safety bill in a generation. The objectives of this bill are to improve vehicle safety and strengthen the National Highway Traffic Safety Administration. With new safety standards, requirements for data recorders, expertise at NHTSA, we hope to restore consumers' faith in the cars they drive and the companies that make those cars. With new resources and tools available, we hope NHTSA will be able to critically evaluate the claims auto manufacturers make about the operation of their vehicle, conduct more thorough defect investigations, and bring about timely recalls when necessary. This legislation is what I call a win-win-win. It's a win for the public by protecting vehicle safety, a win for the auto industry by restoring confidence in their vehicles, and a win for the National Highway Traffic Safety Administration by giving the agency tasked with overseeing vehicle safety programs the resources to do the job. The recent Toyota recalls severely rattled the driving public. This legislation meets the public's urgent concerns. The bill has 4 components. First, it improves electronics expertise at the National Highway Traffic Safety Administration and calls for new safety standards to require brake overrides, to prevent pedal entrapment, and to meet performance requirements for electronic vehicle components. New vehicles would also be required to be equipped with robust event data recorders to assist defect investigators in accident reconstruction. Second, it provides NHTSA with new enforcement authorities, including lifting the cap on civil penalties and granting the agency the authority to order a recall if the agency identifies an imminent hazard of death or serious injury. Third, it requires greater transparency of early warning data submitted by companies to help NHTSA identify defect trends and restores judicial oversight of agency decisions to deny a defect petition. And finally, the bill addresses NHTSA's chronic resource deficiency for vehicle safety programs with an increased authorization of appropriations and the introduction of a modest user fee. In addition to Chairman Rush, I want to thank Chairman Dingell for his contributions to this draft. I know that Chairman Dingell still has concerns about the bill, but he and his staff made many helpful and important contributions to the draft language, and it's my goal that when we report this bill from full committee, Chairman Dingell and I will support the final product. I also hope that we'll be able to earn the support of Ranking Member Barton and other members on his side of the aisle, so this will be a true bipartisan effort. What this bill does not do, and what no legislation can do, is ensure that NHTSA has the willingness and leadership to use its authority to the fullest extent. For that, we are relying on you, Administrator Strickland, and I must take this opportunity to commend you for your leadership overseeing the agency's response to the Toyota situation, beginning just moments after your confirmation. It's clear that together with Secretary Hood, you are committed to putting NHTSA ahead of the curve when it comes to safety, and it's our intention to make sure this bill gives you the authority and the resources you need. Thank you, Mr. Chairman.
Thank you, Mr. Chairman.
Thank you, Mr. Chairman. Okay. Chair now recognizes Representative Sutton from Ohio for 5 minutes.
How does that work?
Should we go to Stearns first? Sorry about that. We got a vote coming up, so we'll try to get as many in as we can. Representative Stearns from Florida is recognized for 5 minutes.
Thank you. Mr. Chairman, thank you for holding this hearing on a draft bill. It's a draft bill, the Motor Vehicle Safety Act. I understand, I think all of us do on this committee, the importance of needing to improve the National Highway Traffic Safety Administration, NHTSA's ability to handle and manage automobile recalls, and the need for some changes to its safety authorities. That's, I think we all agree. I support enhanced motor vehicle safety protections for American consumers, but frankly I do have some concerns with the draft bill as currently written. To begin with, this bill mandates that all auto manufacturers equip their vehicles with an event data recorder, an EDR, within 2 years, and also mandates the collection of additional specific data. Most vehicles on the road today already have EDRs. This bill will allow the government access to all sorts of new information that these EDRs record in the name of, quote, improving vehicle safety, end quote. My colleagues, there are some serious concerns about privacy here. What is the information they're going to collect, and how is it going to be used, and will the consumer know about it? This bill also contains a brand new tax, as mentioned, an auto manufacturer's tax. It's phased in at $3 per vehicle and increases to $9 per vehicle within 3 years. Now, this is a tax. This is not within the jurisdiction of this committee. We have no oversight of it. We also need to steer clear of dictating the way cars are designed, where parts are placed, particularly when it is unrelated to safety and there's no specific evidence demonstrating an identifiable problem. This bill contains overly prescriptive rulemaking authority for NHTSA to determine the size, location of all keyless ignition systems, and a pedal placement standard. Manufacturers may have to redesign their current system. Obviously, those costs are going to be passed on to the consumer. This bill has serious economic ramifications. There's a $80 million increase for NHTSA. Many of us concerned about that. I think we all agree that NHTSA needs some support. But this $80 million, how is it going to be spent? Where is it going to be used? Is it going to hire more bureaucrats, or is it actually going to make a difference? There are additional problems with the elimination of a cap on civil penalties and the broad new eminent hazard authority that requires no fact-checking. So I hope, Mr. Chairman, we can move this bill forward, but in a bipartisan manner, because I think the bill needs improvement today. Thank you.
Thank you. We've got the votes pending, so I'd encourage people if they could maybe keep their opening statements a little bit shorter. We could get to a couple more people before we adjourn for a short break. I recognize the gentlelady from Ohio, Congressman Sutton.
Thank you, Mr. Chairman. Over the last few months, consumers have been alarmed by the recall of millions of Toyota vehicles due to unintended acceleration. For consumers, the safety of a vehicle is a top priority, which is why it was especially daunting to learn that for Toyota, the decision of whether to recall vehicles on our roads was made outside of the U.S. Our consumers expect better. And with the Motor Vehicle Safety Act, we have the opportunity to ensure that NHTSA's mission to save lives, prevent injuries, and reduce economic costs due to road traffic crashes is accomplished. It's essential that we work together to produce a good bill, a bill that will address the problems that have become apparent in recent months. NHTSA must be capable of conducting necessary in-depth investigations into new and complex systems and lighter materials in vehicles. NHTSA must also be able to effectuate necessary timely recalls so that U.S. officials are not left in the position of having to travel overseas to ask for a voluntary recall of unsafe vehicles on our roadways carrying our families. And we must find a way to address the revolving door issue so that the American people can be assured that officials are always working to ensure the safety with the sharp focus that it requires. The Motor Vehicle Safety Act also would require NHTSA to promulgate a rule that requires all vehicles to be equipped with an event data recorder, which I think is overdue. In 2004, some automakers urged NHTSA to adopt a federal motor vehicle safety standard that mandated the installation of event data recorders on passenger cars and light trucks. NHTSA did not go forward at that time with the proposed rulemaking for EDRs, and that was 6 years ago. So I'm concerned that the issues with the unintended acceleration in recent months may also delay the agency's rulemaking of stability control for commercial vehicles. And I'd like to hear about when NHTSA plans to release a notice of proposed rulemaking for stability control systems for commercial vehicles. I want to stress that I appreciate your commitment to fulfilling NHTSA's important responsibilities, Administrator Strickland, and the commitment of Secretary LaHood, and I look forward to hearing from you and all of the witnesses today about ways we might improve the Motor Vehicle Safety Act. Thank you.
Chair recognizes Mr. Latta from Ohio for 2 minutes.
Thank you, Mr. Chairman. Ranking Member Whitfield, thank you for holding this hearing today to discuss the discussion draft on the Motor Vehicle Safety Act of 2010. I think it is very important that the United States looks at the recent incidents involving motor vehicle safety and ensure that our citizens are safe behind the wheel. With that in mind, I have serious concerns about this draft legislation, and particularly with privacy concerns and user fees that will be passed along to the consumers. Section 401 of this legislation requires a new per-vehicle manufactured user fee. This provision is not capped under the proposed legislation will be passed along to the consumer. My district, the 5th of Ohio, currently has an average unemployment rate of 13.5%. The federal government cannot continue to hinder businesses and consumers with unnecessary fees and burdensome regulations. In addition, I have concerns with Section 107 mandating the EDRs in all new vehicles within 2 years. Not only will this mandatory requirement drive up the cost of the manufacturer, which will, again, be passed along to the consumer, but will, with no opt-out provision or ability to turn the device off, will bring serious privacy concerns for American citizens. While it's my understanding that 80% of new cars sold today are equipped with EDRs, there are still remain significant privacy concerns dealing with the rights of what information the government has access to, including information gathering for court orders, defect investigations, and vehicle safety improvement information gathering. Finally, this draft legislation will authorize $720 million from fiscal year 2011 to 2013 and 2011. From 2011 until 2013, this is an $80 billion increase in authorized funding without an explanation on how these additional funds will be used by the NHTSA or how it will go towards saving lives. It seems this legislation is in the same theme of hidden costs and tax increases on the hardworking Americans. In a time of economic hardship, this legislation looks to force more bureaucratic mandates on businesses. Our nation's economic future requires that this Congress and administration exercise serious fiscal restraint and stop excessive spending and be held accountable and be transparent. Mr. Chairman, I appreciate you holding the hearing on the Motor Vehicle Safety Act of 2010. I look forward to working with you and Ranking Member Whitfield, and I yield back.
Thank the gentleman. Chair recognizes the gentleman from Michigan, Mr. Stupak. 2 minutes.
Thank you, Mr. Chairman, and Ranking Member Whitfield for holding this hearing on draft legislation to strengthen the National Highway Traffic Safety Administration, NHTSA's authority, and to provide the resources necessary to keep consumers safe on the road. On February 23rd this year, I chaired a hearing on the Oversight and Investigation Subcommittee to examine the response by Toyota and NHTSA to incidents of sudden unattended acceleration in Toyota vehicles. The subcommittee found that NHTSA lacks the personnel, resources, and authority to adequately address and investigate auto safety complaints. My subcommittee will further examine these issues in a May 20th hearing. As we continue to explore the specific failures of Toyota and the federal regulators in this specific incident, it's imperative that we begin the process of enacting legislation to address the weaknesses we already know exist. Through the Toyota investigation, we've learned a lot about event data recorders, or EDRs, and about the problems that exist in allowing federal regulators, law enforcement, and vehicle owners, consumers, access to the data they contain. The new requirements contained in Section 107 of the draft bill making EDRs mandatory, setting a set standard of data they must contain, and ensuring they are accessible with commercially available equipment will provide all parties the information they need to troubleshoot, investigate, and ultimately remedy future safety issues. Granting NHTSA imminent hazard recall authority is an equally necessary step to protect Americans. I'm also pleased the committee draft requires that information submitted through the early warning reporting system is publicly disclosed. I look forward to delving into these issues more thoroughly and hearing from our witnesses as to whether the disclosure requirements in the draft legislation adequately provide regulators, law enforcement, and consumers access to the information they need. I look forward to a productive hearing to discuss meaningful improvements to the National Highway Traffic Safety Administration and to our additional oversight hearings. I appreciate the willingness of our witnesses to be here, and I will listen closely to any suggestion they may have to improve this legislation. And I yield back, Mr. Chair.
Thank the gentleman. We're gonna have one more opening statement before we adjourn for the votes. I recognize the gentleman from Louisiana, Mr. Scalise.
Thank you, Mr. Chairman. Appreciate you having this hearing today on the Motor Vehicle Safety Act. I'd like to acknowledge Chairman Rush for bringing this legislation forward and his hard work on behalf of consumers. The goals of this draft legislation, strengthening NHTSA and improving vehicle safety, are good, but I have concerns about the steps it takes to get there. To start with, Section 202 provides NHTSA with new, expansive, imminent hazard authority to order a manufacturer to stop production, sale, distribution, or importation of vehicles. I'm concerned that this provision would short-circuit the recall process, not improve it, and it will give unilateral authority to the administrator while taking away due process from manufacturers. What is more alarming is that this provision is in the draft while DOT Secretary LaHood and NHTSA Administrator Strickland both previously testified that they had existing authority to pursue potential violations. The draft legislation also places a vehicle safety user fee on manufacturers, which is, of course, another word for a tax increase that will raise the cost of buying a car on families. Furthermore, this tax is uncapped and would continue to rise each year after it's enacted. Not only does the draft increase the cost of vehicles for consumers, but it also increases the burden of American taxpayers by raising the authorized funding for NHTSA by $80 million over 2 years, with no explanation of where this new spending will come from or how the money will be used. While I understand that we need to examine improving NHTSA's capabilities, we must keep in mind the need to restore fiscal discipline. With a $1.5 trillion deficit, there might be some in Washington who don't see anything wrong with increasing a budget by 40% over 2 years, but there are also those of us who are adamant that we must rein in the out-of-control spending that is taking place here in this Congress. And finally, there are also two provisions I must mention. Section 201 eliminates the total cap on penalties, and the second provision is 301 that expands the categories of data that must be made public as part of any early warning reporting program, which could include confidential business information and unwarranted claims. Removing the cap on total penalties and requiring the disclosure of proprietary information makes me question who we're trying to strengthen, NHTSA or the trial lawyers. I'd like to close by reiterating that I'm pleased we're trying to improve vehicle safety and support NHTSA, but I'm concerned that this bill is driving down the wrong road. Thank you, and I yield back.
Thank you, Mr. Scalise. I've been promised by the next two that they'll do 30 seconds real quick. Mr. Green of Texas.
Mr. Chairman, I'd like to ask unanimous consent for my full statement be placed in the record and just make one statement. I introduced H.R. 5169, the Event Data Recorder Enhancement Act. The draft bill, our bill, I think, looks at it's the Chevy, whereas what the draft has is more like the Mercedes, and I would hope we could afford the Chevy plan on the EDR. But I'm glad the bills that we have a draft. Obviously, it reaches after our hearing we had heard from Toyota owners. We need legislation, I'd be glad to work with the chair on the bill.
He's recognized for 100 milliseconds. You can do it.
Mr. Chairman, you know I'm from Georgia, not Maryland, so that might be awfully difficult for me to do. But if you'll yield unanimous consent to let me submit my entire testimony, I'll get going quickly for 2 pages. Mr. Chairman, I want to thank you for calling today's hearing on the discussion draft of the Motor Vehicle Safety Act of 2010. In light of recent events that have occurred, it's very important that we use the opportunity today to review the way NHTSA, National Highway Traffic Safety Administration, operates with the ultimate goal of keeping vehicular travel as safe as possible for drivers across the country. Mr. Chairman, while I believe that it is important to review the actions and work of NHTSA, I think that it's equally as important that we do not move forward on legislation that would add duplicative mandates on the transportation industry or create more of a burden for the already struggling American taxpayer. So I certainly hope that we keep this in mind as we hear from a witness today and work to craft the proper legislation to reauthorize NHTSA. And I yield back, Mr. Chairman.
Thank the gentleman. Mr. Braley, do you want to enter something into the record?
I just want to make a very brief comment. I'm a firm believer in the power of symbolism. And as I was coming back from baseball practice this morning, Mr. Chairman, I saw a Ford Maverick with a Ron Paul sticker on it. And it reminded me that the Maverick was the predecessor of the Ford Pinto, which was introduced in 1970, the same year that NHTSA was founded. And as we consider the important subject matter of this hearing and how we go about improving safety for all auto consumers and passengers and operators in this country, I think it's important to think back over the history of this agency and the important mission that it has, and that's why I will yield back the balance of my time and rush to the floor to vote. Thank you.
We're gonna adjourn the committee for the votes. When we come back, we'll go straight to the first panel. We appreciate your patience. We're adjourned. Thank you.
The subcommittee is was called back to order. The chair really want to, first of all, extend my deep and sincere apologies for the delay. It's just the way we've had to move today. We've had a number of conflicting items on the agenda, and so we had to try to cover a lot of bases. And now the chair want to recognize the esteemed administrator of the National Highway Traffic Safety Administration, the Honorable David Strickland. Mr. Strickland, we really appreciate the fact that you have taken your time to be here and that you have been so patient with us. And you're recognized now for 5 minutes for the purposes of an opening statement.
Thank you, Mr. Chairman.
Before I do ask or recognize you, Mr. Strickland, I would ask that you allow me to swear you in. That's the practice of the subcommittee. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Let the record reflect that the witness have answered in the affirmative. And now you're recognized for 5 minutes.
Mr. Chairman, thank you so much for this opportunity. Mr. Whitfield and other members of the committee, again, the men and women of NHTSA, thank you for the chance today to discuss the proposals to strengthen the authority of the National Highway Traffic Safety Administration. I applaud the committee members and their staff for working so hard to understand these issues and for reflecting that understanding in the committee draft of the Motor Vehicle Safety Act of 2010. Time has not permitted full review of all of the draft legislation's provisions throughout the executive branch, so my remarks will be confined to some of the major provisions. Today's hearing is an opportunity to work together to improve the safety of our nation's roadways. We very much appreciate the provisions in the committee draft that would enhance NHTSA's Vehicle Safety Authority. NHTSA is a strong agency. The bill's authorities would make us stronger. If enacted, these measures would significantly increase the agency's leverage in dealing with manufacturers. The addition of Imminent Hazard Authority would bring NHTSA's authority into line with many of its other sister safety and health agencies. This provision gives NHTSA an important avenue through which to deliver on its consumer protection mission, a mission that I strongly believe in. As part of that safety mission, NHTSA collects a wealth of information in its various databases. We share in President Obama's assessment that information contained by the federal government is a national asset. This proposed bill would require NHTSA to improve the accessibility of the information on its publicly available databases. We will be very happy to do so in looking at several ideas on how to make our recall and our investigations data more user-friendly. Even in the current state, NHTSA's information stores are among the most outstanding consumer safety databases in government. Improving them would promote transparency. Transparency promotes accountability and provides information for citizens about what their government is doing. I will work with the Secretary and the Congress to strengthen and improve NHTSA so that it can continue to achieve its mission in saving lives, preventing injuries, and reducing economic costs due to road traffic crashes. We will be accountable to the President, to Secretary LaHood, and to the American public for whom we at NHTSA proudly serve. Thank you very much, Mr. Chairman, and I look forward to answering the questions of the committee.
The chair thanks the witness. Now, the chair recognizes himself for 5 minutes for questioning the witness. Mr. Strickland, I have a lot of respect for you. I know you and I've known you and your family for quite some time and have nothing but, I'm very proud of you and what you've accomplished. And I'm proud of the things that you have done in terms of your public service work. But I'm a little disappointed, I must say, in your opening statement. I have to be very honest with you. This legislation, first of all, I know that there's a process for developing testimony in the executive branch. And I am real cognizant of the fact that you only have a short turnaround time in terms of developing your testimony here. But that said, there's really just a gaping hole that exists in your testimony. There's a complete lack of detail that I was expecting, and I know that you are capable, and I've seen you do this in the past.
Yes, sir.
But there's a lack of detail in your testimony that leaves us kind of wanting as a subcommittee. This legislation that's before us aims to overhaul your agency, providing it with new enforcement authorities and additional resources. And we're glad to do this. We're proud to do this. We're giddy about doing this for NHTSA and giving it new authorities and resources. And it also mandates several new safety standards and create new transparencies in auto safety. I know that you got more to say in regards to it, whether it is in this bill or not. What do you see as the most important new authority Congress could grant NHTSA that would strengthen the agency and improve auto safety? What is the most important new authority that you need?
Well, Mr. Rush, I definitely do not want to disappoint you or the rest of the committee with the breadth of my statement. As you are aware, that we at the Department of Transportation and also with the executive branch do have a process in which we evaluate both discussion and introduce legislation, and that is in process. I apologize profusely that we were not able to give you a more granulated and detailed assessment of the work, that will be coming. I will be more than happy to provide that more detailed recitation when it is completed the review. Happy to appear before the committee if that is your wish to do so at that time, but I will do my best to try to fill in some of the issues that you wish to discuss. The bill, to give an overview, anything that provides NHTSA the authority to be able to expedite the recall process, whether it is in negotiating with the manufacturers of trying to get them to issue a voluntary recall, or an ability for the agency to be able to move forward in a fashion, if we had to do so in a mandatory fashion, such as with the Eminent Hazard Authority. Those are the core, I think, of what we will want to achieve here at NHTSA, which is to be an agency that can take risks off the road as quickly as we can. And anything in this legislation that helps us achieve that is something that I believe that NHTSA would wholly embrace. There's lots of details in part of those new authorities and process that we will stand at the ready to discuss. But anything that helps us achieve that goal, which is including the increase in penalty authority, I think the opportunity for us to really have a penalty that creates a real deterrent for manufacturers and equipment manufacturers as well to not violate the act, I think helps in that leverage and negotiation process, and also helps those manufacturers make quicker decisions in terms of safety.
Right. My time is running down, but the other question that I have, what's missing from this bill in your opinion? Is there what's missing? What can we do additionally?
In our evaluation, our preliminary evaluation and discussions with your staff and other staff members, this does capture the universe of what I think of what would be helpful to NHTSA. There are clearly other things that could be of assistance, but in terms of what we would anticipate as being helpful to strengthen the authority, the bill does give a fantastic foundation for the first steps in helping us be a stronger and more transparent agency.
The chair yields back the balance of his time and recognizes the gentleman from Kentucky, Mr. Whitfield, for 5 minutes.
Thank you, Chairman Rush and Mr. Strickland, for your testimony. I, for one, am pleased that you all are reviewing this legislation carefully, because it would bring about significant changes not only to NHTSA, but certainly to a lot of manufacturers around the country, as well as to consumers. And I do think it's imperative that you all take the necessary time to look at this closely. You testified before our committee not too long ago, and if I were the administrator of a federal agency, I would be thrilled if some legislation came along giving me new authority, giving me new money, and so I can understand how you all would not be opposed to this legislation. But when you testified before, I mean, the important thing is that you be able to do your job, which I think NHTSA is doing. But you testified before that you have engineers at NHTSA, you have electrical engineers at NHTSA, you have software engineers, you have engineers in East Liberty, Ohio. You can hire consultants for additional expertise. And you said there is not a notion that we don't have the proper expertise to handle today's automobiles. And then Mr. Dingell asked you a question, and I know that President Obama has given you additional money in his budget for this year. And you said when the president's budget is passed, we will have the resources we need. And you know, that's all we can expect from people who have the responsibility for these agencies in our government, is to give us an honest, candid view of whether or not they have adequate resources. And you said very clearly that you had adequate resources. So many of us feel like that this bill is too broad, but I want to ask you this question. The center that this bill establishes the Center for Vehicle Electronics and Emerging Technologies. Is there such a center similar to that at the Department of Transportation for railroads or for airlines or for any other type of transportation?
I'm not familiar if there isn't a similar center that focuses on a particular area. I'll have to get back to you on the record with some specificity. I may be incorrect in that, but from my recollection, I don't believe there is one.
Was your opinion solicited on whether or not this center should be placed in this legislation before the draft was written?
We were not asked in terms of to give a particular comment when the discussion draft was transmitted to the Department of Transportation. We put it in for internal review and also sent it over to the White House also for their review. So we have not issued an opinion about that particular concept at this time, but when we have finished our review, we will definitely transmit that opinion.
But it sounds like you were not really involved in drafting this legislation, your agency, and providing information to draft this legislation.
No, sir. We were asked from, we were consulted in terms of concepts, but the actual technical assistance in drafting was handled by the committee staff.
Would
well,
the
you know,
chairman yield?
Yes,
Please?
yes, sir.
I thank you. Would you make that review available to this committee as soon as you can, please?
Yes, sir. Absolutely, Mr. Dingle.
I thank the gentleman.
I wish that they had talked to you in some detail before this legislation was written, because it is your agency's responsibility to carry out the role and the responsibility. And if there was any group that would have a clear understanding of this, it would be your agency. One other question I'd just like to ask. Toyota was fined, I think, $16 million, which I guess was the maximum
yes, sir,
fine
that's
that
correct.
could be levied. How did you actually, how was it actually determined what that dollar value should be on that, for that fine?
Well, it's I mean, it's actually a straight calculus of the actual violation and the times the number of cars that were in violation. If I'm not mistaken, I believe if there was not a cap that limited to us to $16.375 million, I believe the fine could have been well over $13 billion for the entire population of cars that were subject to the violation of the timeliness query.
It could be over how much?
$13 billion.
Billion.
Yes, B.
You had that authority.
If that would be the maximum 5 per violation, but we are limited to $16 million. I believe that our recitation and breakdown of the possible maximum fine without the cap was included in our demand letter to Toyota.
Okay, thank you.
The chair now recognizes the chairman emeritus of the full committee, who graciously relinquished his time for an opening statement to be used now during the time of questioning, time for questioning. So the chair recognizes the chairman emeritus for 10 minutes for the purposes of questioning the witnesses.
Mr. Chairman, I thank you for your courtesy. I commend you for the hearings. My questions, Mr. Administrator, will be answerable yes or no. The first question. Title 1 of the discussion draft under question mandates that DOT prescribe new federal motor vehicle safety standards for passenger cars without any preliminary study by NHTSA or DOT or any of them. Is DOT or NHTSA sufficiently prepared to undertake such rulemakings for each of these proposals without any preliminary study of the need, practicality, and appropriateness of each such rules for all manufacturers and their models? Yes or no?
NHTSA at this time is beginning its preliminary research.
No, I want a yes or no. I have limited time. Yes or no?
At this particular juncture, Mr. Dingle, we are preparing to undertake the possibility of rulemaking.
So you're not at this time prepared. You're not prepared to answer the question, or you're not prepared to perform the rulemaking without the necessary studies. Which?
We have work underway for all of those things right now.
I don't want to filibuster. I just want a yes or no answer. I know that's going to be fairly easy once we get to working together.
Yes, sir. Mr.
Yes
Dingle,
or no?
at this time, no, we would not be prepared to go to
Very
immediate
good.
rulemaking
Thank
on
you.
those issues.
It's really easier than we thought, isn't it? Now, my reading of Title I of the discussion draft shows that it does not amend the existing Safety Act of Title 49 of U.S. Code, and thus does not require any new federal motor vehicle safety standard to be prescribed in accordance with Section 3011 of the Safety Act. Do you agree?
As
yes,
drafted, that is
no?
correct. Yes, Mr. Dingle.
Thank you. Now, Mr. Strickland, further, to my knowledge, there is nothing in Title I of the discussion draft that would make these new standards subject to the provisions of the existing safety statute and thus enforceable. Is this observation correct, yes or no?
That is a correct observation, Mr. Dingle.
Thank you. Now, Mr. Administrator, as you know, the Safety Act generally applies to new motor vehicles because Title I of the discussion draft does not amend the Safety Act and thus is not subject to the Act's definitions. Is it conceivable that the term passenger vehicles, as used in the discussion draft, would include new cars and cars also that are already on the road? Yes or no?
It's not conceivable, sir. I believe it would only apply to new cars because the definition is cross-applied throughout Title 49. So, but we will definitely be happy to give technical assistance to ensure that.
Is the answer yes or no?
Is it conceivable? No, it is not. It will only apply to new cars.
It will not?
It will not be retroactive.
I would like to have you submit further information
yes, sir.
as to why you make that statement. The rule proposes in Title I of the discussion draft each provide lead time requirements of 1 or 2 model years, and in one cases 60 days after enactment for all makes and all models of passenger cars without any determination by the Secretary as to the reasonableness and practicability of those deadlines for applicable rule. Does DOT today know that such lead times are realistic and practical, taking into consideration energy, needed technology, impacts on models, as well as costs of appliance? Yes or no?
Past practice and rulemaking, those are very aggressive deadlines.
Just yes or no, if you please.
No, sir. I believe that those deadlines are impracticable at this point.
You believe what?
I believe that those deadlines are very tight and possibly impracticable until we can actually work with the manufacturers in terms of meet lead time needs.
Thank you very much, Mr. Administrator. Now, Mr. Administrator, my understanding of the Federal Motor Vehicle Safety Standards is that they are almost universally performance standards, yet only one proposal, Section 104 on electronic systems, calls for a performance standard, while event data recorder and brake override proposals are quite prescriptive. Is DOT now ready to develop such prescriptive rules and know definitively that they will provide, quote, motor vehicle safety, close quote, as the term is defined in the Safety Act? Yes or no?
Research is underway. The NHTSA is not prepared to do that at this time.
Okay. Now, Mr. Administrator, with respect to Section 201, the discussion draft related to civil penalties, I note it contains no provision for judicial review or penalty assessment criteria, such as the size of the business, economic impact, history, duration of the violation, seriousness, and willfulness. EPA must take into account these factors when assessing civil penalties under the Clean Air Act, and under your administration are other provisions requiring similar actions. Should the Safety Act be amended to include possible judicial reviews of penalties and require DOT to take into account penalty assessment criteria such as EPA must? Yes or no?
May I get back to you on the record for that specifically, Mr. Dingle?
Mr. Administrator, the discussion draft strikes the maximum penalty for a related series of violations. Do you believe that this is justified especially in view of the fact that the Safety Act contains no provision for judicial review of penalties or require the Secretary to take into account any penalty assessment criteria? Yes or no?
There's factors that we currently consider for the evaluation of a penalty right now for our current authorities. That would cross-apply to this situation. So as drafted, the NHTSA would take those into consideration before assessing a penalty.
How could you do it if you're not required by law?
It is by our current administration practice in assessing penalties.
So that's just policy which can change with the wind. Mr. Administrator, Section 202 of the discussion draft allows the Secretary to issue an imminent hazard order against vehicle manufacturers. Does DOT have a definition for the term imminent hazard, either in the regulation or the statute? If you have such, will you submit it for the record?
Yes, sir, I will.
Now, Mr. Administrator, likewise, Section 202 permits the Secretary to issue such imminent hazard orders absent prior judicial review and consent. Should DOT have to show by suit in federal court that hazard is imminent, just as EPA must do under Section 303 of the Clean Air Act and CPSC must do under Section 11 of the Consumer Product Safety Act, as opposed to forcing the aggrieved person to seek judicial review at the circuit court level where there is no trial of facts? Yes or no?
I'd like to get back to it from the record for that, Mr. Dingle, but to let you know that our sister modal agencies, such as the Federal Rail Administration and others, have similar imminent hazard authority as drafted by the, as seen in the committee draft.
This is not, remember, Mr. Administrator, tied to the Automotive Safety Act nor to the Administrative Procedure Act. Now, Section 301 of the discussion draft requires DOT to conduct rulemaking on disclosure of information about vehicle defects, repairs, etc., with a presumption favoring maximum public disclosure. Given that DOT has existing regulations on public disclosure and must comply with the Freedom of Information Act, is such a disclosure rulemaking as the discussion drafts mandates, yes or no?
I'd like to get back to you on the record for that, Mr. Dingle.
Mr. Administrator, Section 401 of the discussion draft requires vehicle manufacturers to pay an annual fee on a per-vehicle basis. Such fee shall be used, according to the discussion draft, to meet the obligations of the United States to carry out the vehicle safety programs of the National Highway Traffic Safety Administration. To the best of my knowledge, these obligations are not defined in the discussion draft. Do you agree, yes or no?
The obligations are not defined. We're happy to get back to the record on that question.
Now, Mr. Administrator, the discussion draft sets out per vehicle fees to meet NHTSA's obligation. Absent a clear definition of these obligations, do you believe that the levels of these fees as defined in the discussion draft are arbitrary? Yes or no?
I'd like to get back to the record for that, Mr. Dingle.
Mr. Administrator, similarly, is DOT in possession of any information that would verify the level of these fees is appropriate to meet its obligations, whatever they might be? Yes or no?
I'll respond to you on the record, Mr. Dingle.
You don't know?
At this point, we have the 2011 budget that the President has issued to the Congress.
The answer is, though, Ms. Secretary, you don't know. Or rather, Mr. Administrator, you don't know.
At this point, sir, we have allocated our budget for the 2011 budget. The levels that are produced in this bill, we are happy to review.
The question is, you still don't know. Mr. Chairman, you have been most gracious on your gift of time to me. I express to you my thanks, and also to my good friend from Kentucky, my gratitude for his kindness in yielding to me earlier. Thank you.
The chair thanks the chairman emeritus, and now the chair recognizes the gentleman from Ohio, Mr. Space, for 5 minutes.
Thank you, Mr. Chairman. Thank you, Mr. Administrator, for your testimony today. I want to shift gears and talk a little bit about the testing center in East Liberty, Ohio, that NHTSA has. And there is no suggestion in this bill that that facility be abandoned, but there have been some suggestions externally about the prospect of moving it. And the impetus behind those suggestions has been that because the facility is technically owned by the Honda of America Manufacturing Corporation, that would represent some kind of a conflict of interest. And I guess my question to you is, are you familiar with the facility I'm talking about?
I'm very familiar with the facility.
And you're familiar with the fact that the facility itself, though owned by Honda, is actually operated pursuant to a management agreement by a not-for-profit corporation that was founded by the Ohio State University?
That is correct.
Okay. And in your experience, have you in the past been alerted to any problems associated with the ownership, and specifically that may have arisen as a result of a conflict of interest?
Mr. Space, my job before I was sworn in as administrator of NHTSA, I was an oversight council, which which part of my bailiwick was oversight of National Highway Traffic Safety Administration for over 8 years. I was very familiar with the ownership structure of the VRTC with TRC in Ohio State. I never had any knowledge of any conflict of interest during my time as a staffer. I took a look at this issue very specifically when this was brought to my attention. I've seen no indication whatsoever of there being an improper relationship. It is a firewall relationship between TRC, the Ohio State University, for whom we pay, and Honda of America, which actually owns the land.
Thank you, Mr. Administrator. Are you aware of any other manufacturers apart from Honda that may have registered complaints about the ownership structure of the facility?
There have been no complaints from any manufacturer.
And finally, has the weather been a problem? The Ohio weather been a problem? I know we don't have the claim to snowpocalypse, but I'm curious as to whether that's been a problem for the facility.
Our staffs have been able to use the pad and the other facilities. That has never been an impediment to our work in terms of the availability of the actual test track itself or the buildings that we use.
Okay, thank you, Mr. Administrator. I yield back my time.
The chair thanks the gentleman. The chair now recognizes the gentleman from Iowa, Mr. Braley, for 5 minutes.
Thank you, Mr. Chairman. Mr. Strickland, thank you for joining us again.
No, thank you, Mr. Braley.
And I want to start with a follow-up question to Mr. Dingell's question to you about the scope of administrative judicial review. And I want to make sure that I understood your response as it relates to NHTSA. Because my understanding is that a general rule, any federal agency that falls within the Federal Administrative Procedure Act, in order to overturn the action of the agency, you have to demonstrate in that judicial review process that the action of the agency was arbitrary and capricious. That is the baseline definition of judicial review for any federal agency action. Is that your understanding?
That is correct, Mr. Braley.
But that Congress may, if it chooses to, also include in the organic law that gives rise to that agency action more limitations on judicial review, if it chooses to do so.
Yes, Mr. Braley, that is correct.
So the mere fact that there is not specific language giving further direction on what should be considered as part of that judicial review of NHTSA's action does not mean that there is not a formal process for judicial review subject to the baseline arbitrary and capricious standard.
Mr. Braley, you are correct in that analysis.
All right. Now, one of the concerns that I had and many people had during the period of the Bush administration and its operation of NHTSA was that the agency during that period, specifically from 2005 to 2008, seemed to many of us to usurp its own regulatory authority and take on the role of Congress by including in many of its preambles issued in response to regulations language preempting state law claims.
Right.
Are you familiar with that practice?
Yes, sir, I am.
And I know that the president himself at the beginning of his administration took a strong position rolling back some of those some of those statements made by agency representatives in those preambles and in the regulations themselves. Are you able here today, as a representative of the administration in your capacity, able to assure us that those practices will not continue while you are administrator?
I can make that obligation, absolutely. There is a notion that states' rights are incredibly important, and those preambles that were placed not only in NHTSA's rules, but there were several rules throughout executive branch agencies and safety agencies which undermine safety. And I know the Obama administration felt very strongly that those should not be used to undercut the notion of safety, whether by the federal government or in the states.
Thank you. One of the things that this Motor Vehicle Safety Act calls on your agency to do is to improve the public accessibility of information posted to its website. And that includes a requirement that you make sure that all data is searchable and can be aggregated and downloaded. As it exists now, does NHTSA have the capability to ensure that this information is posted in an easily accessible and searchable fashion that any member of the general public can use?
At this point, we recognize, I have sort of two things to say about that, Mr. Braley. Even in the current state of NHTSA's database, it is clearly one of the most usable and transparent databases in government. We found that consumers and the press and members of Congress have been able to go through our work, been able to analyze it independently of what we have done. So I think that speaks to the level of transparency. But at NHTSA, we do recognize that it could be more user-friendly and more accessible. And we have efforts underway right now to deal with some of those issues, including creating a VIN-based identifier system to ensure uniformity of and usage of vehicle configuration details. The vehicle owners questionnaire, the VOQ, is very difficult. I know our goal is to make sure that we can make it simpler and that drivers and consumers use less time in filling out the VOQ so that we can get more information from more consumers. We have a significant abandonment rate. We get over 30,000 complaints a year, but there's a lot of people that begin the process that give up because it is such a difficult form to fill out. We need to be better there, and there's lots of other things that we are currently undertaking. I know the draft legislation makes mandates and suggestions for us to undertake that opportunity. We will continue our own work independent of the legislation. If this legislation becomes law, we will happily work on making the database more consumer-friendly and more usable.
Well, I'm very glad to hear that. I'm shuttling back and forth between two hearings, one on transparency and pricing in healthcare, and this hearing, which also has placed a huge emphasis on transparency. And transparency is great, but unless you're communicating with your intended users in language they can understand, all that you do is create more frustration, and you keep people from getting access to the information they need to rely upon to make informed decisions. That's why I'm proud in both the 110th and 111th Congress, we in the House have passed my Plain Language and Government Communications Act requiring all federal agencies to communicate in their publications and their web-based services with constituents in a language that they can understand, and I would be happy to work with you and your agency as they try to adopt some of those best practices.
Now, Mr. Brealey, that will be a great opportunity for us. And also, I'd like to take this opportunity to promote the new NHTSA website at NHTSA.gov. We have simplified the website, made it much more user-friendly, and I would hope that you and the other members and the staff would take an opportunity to go on NHTSA.gov and to please give comments on what we have done. We're very proud of the work in terms of making it better for the American consumer.
Thank you. I yield back the balance of my time.
Thank you, Mr. Braley.
The chair thanks the gentleman. The gentleman from Michigan, Mr. Stupak, is recognized for 5 minutes.
Thank you, Mr. Chairman. Mr. Strickland, when a consumer buys a car and it has a EDR in there, should the consumer, the owner of that vehicle, have access to that information?
At this point, we're reviewing several issues about EDRs, and we'll happy to get back to you on the record, Mr. Stupak. But in terms of the privacy issues, there's several considerations that should be undertaken, and NHTSA and the administration are looking at those things very closely.
Well, is there anything like proprietary information that would be revealed if the consumer had an opportunity to look at what was happening with their vehicle at the time
I wouldn't be familiar in terms of the accessibility of a consumer and what data may be considered proprietary. At this point right now, EDRs only track acceleration and braking. I know that there's other considerations in the discussion draft which may include more information on the EDRs. Happy to get back to you on the record for that consideration as well.
With the gentleman yield.
Yes.
Could you cite any provisions in the discussion draft that protect either proprietary information, trade secrets, or data which is important to the company as a competitive matter?
There's no language in the draft that does any of that, Mr. Dangle.
Thank you. And I thank the gentleman for yielding.
Well, what's really, if you get these EDRs, what's the difference if I turn on my Sirius radio and I listen to certain music, and that's mine, right? I can put in any station I want on my Sirius radio and listen to it. So in my EDR, if I want to know how fast I was going or accelerating or things like that, why wouldn't I be entitled to that information, being the consumer? The owner of the vehicle, if you will.
The owner of the vehicle should have access to all aspects of the vehicle in terms of information provided. I think that in terms of transparency and clarity, I think that for a consumer to have that ability to access it, and actually the consumer does have the right to access that information. They may not have the tools to get the information, but I believe the consumer always has that right at this point, if I'm not mistaken.
Okay, so if there's an accident, like sudden unattended acceleration, what right does Toyota have to come in and remove that information or withhold that information from consumer?
Well, that in terms of now, I'm not as familiar with how that interplays. I know the manufacturer can access the data. I know that NHTSA has an ability to access the data once we get an okay from the consumer. But in terms of the preventing a consumer from getting the data, him or herself or Toyota preventing, or any manufacturer limiting access to that data, I am not as familiar with that process. I'll have to get back to you on the record.
Right. Have you demanded the information from these recorders on the accidents of the sudden unattended acceleration? From Toyota?
Yes, we have.
Have you received it?
Yes, we have received it. Actually, in addition to getting that information, Toyota has also provided several readers. One of the issues that we were facing, Mr. Stupak, and I believe that those were explained to you in the hearing that you held a few weeks back,
right,
that there was an issue where NHTSA did not have the ability to independently read a Toyota EDR. Toyota has since supplied us several of their readers so that we can access the data on site, and they've been much more proactive in that area.
All right. Have you shared this information then with the victims' families of these sudden unattended acceleration of these vehicles? I'm thinking especially of the one up in New York, the case up in New York.
The Harrison, New York case, sir?
Right.
Okay. I believe at this point right now, my understanding is that we have that data. We're analyzing it for our own investigations. I don't know if there's been a request made to NHTSA to release that information. I will get back to you, sir, when I'll ask the question of the staff.
All right. These new EDR standards, do you believe they're sufficient in the proposed bill, Section 107?
We're actually taking our own independent research on EDR systems, sir. The staff will be producing a white paper that hopefully should be available by June of this year, which will take a look at several issues regarding the sufficiency of the data, the robustness of the EDR, and several other considerations, and we will be happy to share that with you and the rest of the members of the committee. But at this time, we are not prepared to make an evaluation of the discussions drafts mandates regarding
Will
EDRs.
you be looking at what other data may be useful to you, like torquing and arcing on braking and vehicles?
Yes, sir.
Roadway?
It is a comprehensive review in this white paper. We'll take those other considerations into account.
Okay, so now in the Toyota, how many pieces of data do you receive? You said 2, speed and acceleration?
It's speed and braking. It's whether
That's
the accelerator was depressed and when the brake was depressed. That's correct.
Okay.
There's other information available in the vehicle as well, Mr. Stupak, in the electronic control mechanism or the PCM, and which is independent of the EDR, which can also be a very rich trove of information which Toyota has shared with us as well. But the actual EDR itself, it is only braking and acceleration.
Doesn't that seem inadequate? I mean, these standards were put out some time ago. There were more than just 2 standards in the proposed EDRs that we wanted. 2013 they were supposed to take effect, or I'm sorry, 2011, and there was pushed back to 2013. Is that correct?
It's actually a big 2012 is actually, I believe,
okay,
is
2012,
when
split the difference.
The voluntary, about to say, if you do have an EDR, you have certain, certain information you have to provide and make sure that NHTSA makes it readable.
But in that 2012 reader, it had to be more than just speed and braking, wasn't
Yes,
it?
sir, that's correct.
Okay, so we should make sure there are many more aspects that would be helpful to you in and to the consumer in these EDRs.
We're looking forward to working with you and the rest of the committee on this issue, Mr. Stupak.
Thanks.
Thank you, sir.
That concludes the testimony of the administrator. And Mr. Administrator, the ranking member has requested some additional time. So if the administrator will agree, we'll have a second round of questions for 1 minute. And the ranking member is recognized for 1 minute for an additional question.
Yeah, Mr. Strickland, would you please tell us when you expect you would be able to give us a section-by-section analysis of this bill?
At this point, I know it is currently in process within the department and with the administration. My expectation is that hopefully I will be away on travel. I would hope that I will have a more specific time frame and answer when I return from Asia. So I will be more than happy to communicate when we expect to have that review to you. But at this time, I don't have a specific date when we'll have the review done.
Well, I urge you all to speed it up and provide it with us as soon as possible.
Understood, Mr. Whitfield.
One other question. I know that you can evaluate each rulemaking and calculate the cost of that rulemaking or the estimated cost and lives saved. Will you be able to do that with this legislation?
In terms of doing our normal cost-benefit analysis of the rule, one thing that we would have to make sure that we go through regular order and process in any of these rulemakings and find the proper amount of time to execute all of the things we need to do for a rule. We are evaluating the time frames that are present in the discussion draft, along with our current rulemaking load. We have other rulemakings that are in the queue from other pieces of legislation and work we already have done independently. So, yes, we will need to be able to do that work in order for us to justify the rule, and we will definitely do so in that fashion.
Thank you.
Is there any other, well, Mr. Space, do you need, have any additional questions? All right. Mr. Braley, you got? All right. Mr. Strickland? That concludes your time. You've been most gracious with your time. And
no, Mr. Rush, it's my pleasure, and the men and women at NHTSA really do thank you for this effort.
Thank you so much, and God bless you. The chair now will ask that the second panel please be seated at the table. The chair wants to thank you, each and every one of you, for your gracious sacrifice of your time. You've been very patient with us, and the chair wants to recognize you and thank you for it. I want to introduce the panel right now, beginning from my left, a former member of the House of Representatives, the esteemed Honorable David McCurdy, who now serves as the President and CEO for the Alliance of Automobile Manufacturers. David, it's good to see you, and welcome back to the subcommittee. Next to Mr. McCurdy is Mr. Michael J. Stanton. He's the President and CEO of the Association of International Automobile Manufacturers. Welcome, Mr. Stanton. Seated next to Mr. Stanton is our friend who's appeared before this subcommittee on many occasions, the Honorable Joan Claybrook. She's the former administrator for the National Highway Traffic Safety Administration. Welcome back, Mrs. Claybrook. And then seated next to Mrs. Claybrook is Mr. Clarence Ditlow. He's the Executive Director of the Center for Auto Safety. And seated next to Mr. Ditlow is Mr. Jim Hopper. He's the Director of Information Policy Studies for the Cato Institute. Again, welcome to each and every one of you. And it's the practice of this subcommittee to swear in the witnesses. Will you please rise and raise your right hand? you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Please let the record reflect that the witnesses have all responded in the affirmative. And now we will recognize Mr. McCurdy for 5 minutes for the purposes of opening statements.
Thank you, Mr. Chairman, and Ranking Member Whitfield and members of the subcommittee for inviting me back to discuss this draft of the Motor Vehicle Safety Act of 2010. In the interest of time, I'm going to request my full statement be admitted in the record. I'm going to briefly go through some highlights, if I may. And since this is a discussion draft, I hope that this can also be a frank discussion because I think we need to get to the root of some of these issues. There's been a lot of discussion on auto recalls in recent months, so let me start by reassuring the American consumer that we are in a historic period of auto safety in the U.S., and I think Mr. Whitfield mentioned some of the statistics about the declining rate of traffic fatalities and that our roads are safer today, lowest level since 1949. Consumers are benefiting from many innovative life-saving technologies that assist the driver, including electronic stability control, lane departure warning system, blind spot monitors, and adaptive cruise control. We also, if you look at safety in another way, today we see more frequent recalls, but fewer vehicles are recalled compared to a decade ago. That fact suggests that both NHTSA and automakers are effectively spotting early warning signs and taking faster action. If Congress wants to reassure consumers quickly about auto safety, lawmakers should focus on 3 or 4 of these measures that enhance safety the most. And if I may make some recommendations. First, the Alliance supports a vehicle brake override standard that will assure consumers that they can count on their automobiles. Brake override technology is a comprehensive solution to unintended acceleration, whether it's caused by faulty electronics or a pedal getting caught in a floor mat. Therefore, a pedal placement rulemaking, however, would not provide additional safety benefits. So brake override, yes, pedal safety, redundant. The Alliance supports the intent of a keyless ignition system standard to ensure a consistent means of shutting off an engine during an emergency. However, brake override is a preferable solution to unintended acceleration. If a rulemaking is necessary, it should focus on standardizing engine shutoff procedures and not on design features like the appearance or location of the button. The Alliance supports requiring event data recorders in new vehicles, but we are concerned about provisions that suggest they should be like black boxes in airplanes. The typical airplane black box costs roughly $22,000, which is close to the average price of a new car. In my opinion, Representative Green's legislation, H.R. 5169, a member of the subcommittee, is a better approach. A proposed transmission configuration standard is not necessary because such a standard already exists, FMVSS number 102. The Alliance urges Congress to adopt legislation that enhances our knowledge and expertise. We support a Center for Vehicle Electronics and Emerging Technologies within NHTSA. Even in this partisan environment, this is something we can all agree on. We urge Congress to fund the National Automobile Sampling System, or NAS, which has shrunk to 1/3 of its intended size, important data collection. We also urge Congress to fund the Driver Alcohol Detection System for Safety, or DADS, to help identify vehicle technologies that could stop drunks from turning on a car, hopefully saving many thousands of lives each year. There are always trade-offs and competing demands when you're writing legislation. Congress will need to balance some of the proposals with consumer concerns and marketplace concerns. For example, Congress will need to balance the desire for more data with privacy protections for consumers. NHTSA spent many years assessing the data to be collected by EDRs, and we are in the middle of a phase-in period for that standard, so we need time to assess the impact of the first rule before we start writing the next rule. Congress must also balance the desire for more public information with valuable product information. The purpose of early warning data is to enable NHTSA to identify trends and take action sooner, not to create an eBay or Amazon.com where competitors can surf for company trade secrets or lawyers can shop for clients. Citizens are better served when safety legislation empowers engineers, not trial lawyers. Congress will need to avoid the possibility of creating a system of regulation by litigation. Congress should not enact measures that will have the unintended effect of slowing, not accelerating, action on safety matters. If every petition denial is subject to judicial review, NHTSA will be forced to spend substantial resources and time responding to every petition, regardless of its merit, in anticipation of judicial review. This will not serve the agency, the industry, or the public well. Finally, Congress will need to preserve basic fairness and due process under the law. The Alliance does not oppose an increase in civil penalties, but penalties must be capped at some reasonable level. The proposed five-fold increase is surprising since 2 years ago this committee set a cap of $15 million per offense on penalties that could be assessed to manufacturers of other types of consumer products. Regarding granting NHTSA imminent hazard authority, all I can say is that, Mr. Chairman, the proposed provisions need further work. They're so lacking in standards and the opportunity to be heard before a neutral decision maker as, in our opinion, to violate the due process clause of the U.S. Constitution. Furthermore, if Congress, in my experience, has a stick, it will always want a club. Regarding corporate responsibility for NHTSA reports, the proposed personal liability for auto executives would be $250 million. That's 50 times higher than for executives under Sarbanes-Oxley, which resulted from the Enron scandal where executives went to prison. In closing, I know the challenge of getting a consensus. I've chaired several subcommittees and a full committee. This bill can be made stronger by focusing on what's most important, and we look forward to working with you to identify the key provisions that will actually improve safety and benefit consumers. Thank you.
Thank you, Mr. Chairman, and thank you, Mr. Whitfield. I am Mike Stanton, President and CEO of the Association of International Automobile Manufacturers. AAMM and its member companies appreciate the subcommittee's efforts to improve motor vehicle safety and understand the intended benefits of the bill. We also fully support the subcommittee's proposal to provide additional engineering and related resources to NHTSA, including improving the agency's vehicle safety database to provide greater public accessibility. However, AIAM believes that NHTSA must be given the necessary time and flexibility in its rulemakings so it can make good decisions. Similarly, manufacturers require sufficient lead time to engineer, test, and produce vehicles that will meet the new standards. We are concerned that the rulemaking mandates in the draft bill predetermine conclusions as to matters currently under the investigation and not yet fully analyzed by NHTSA. As a general matter, it would be more appropriate to direct NHTSA to complete its investigations as soon as possible and issue rules based upon a full and comprehensive analysis of these important safety issues. Regarding the 9 mandated rulemakings in the draft, we defer to NHTSA's judgment as to the feasibility of the deadlines for issuing the numerous final rules as specified in the bill. However, we note that the deadlines for many rulemaking mandates appear to be unreasonably short and provide insufficient lead time. Short deadlines can adversely affect the quality of the final rule. And prior to issuance of a final rule, NHTSA often finds it necessary to conduct research to address issues that first arise during the rulemaking process. From our perspective, if the short deadlines adversely affect the quality of the final rules, we all lose. With regard to the effective date specified in the bill, we note that while some of our members already equip their vehicles with several technologies contemplated by this legislation, for example, brake override and EDRs, others do not. For those manufacturers who do not currently employ these technologies, especially some of the small volume manufacturers, the effective dates specified in the bill are simply not feasible. Even those companies that currently have these technologies also need sufficient lead time because there are no assurances that these current technologies will be consistent with the mandates in the final rule. In addition, the draft bill does not provide for the new requirements to be phased in, nor does it provide for phase-in incentives to promote early deployment where feasible. It is generally more efficient for manufacturers to implement new technologies at the time of model changes so that the new items can be better integrated than would be the case with a purely add-on approach. With respect to the proposed corporate responsibility requirement in Section 305, we have concerns that this requirement could significantly chill the speed of the safety investigation practices used by some AIAM members and introduce non-safety experts into the process. The current practice used by some AIM members separates safety-related decisions from financial considerations and intentionally excludes these executives. We are concerned that the proposal might have the unintended consequence of introducing financial considerations inherent when highest-ranking executives are involved into that safety decision-making process. We also note that under existing law, manufacturers are already legally responsible and accountable for submitting accurate information to NHTSA. Providing false or misleading statements to the federal government is strictly prohibited. AIAM does not believe that requiring a senior official to certify responses to safety investigations and other submissions to NHTSA is necessary or practicable. However, if the committee insists on some sort of senior officer certification, consideration should be given to limiting the scope of this certification to formal responses to NHTSA's defect determinations. Additional consideration should be given to allowing a corporate officer specifically charged the safety matters to certify submissions. Mr. Chairman, my written testimony provides AM comments on most of the sections of the bill, and I'll be more than happy to answer questions at the appropriate time.
The chair recognizes the Honorable Ms. Joan Claybrook. Ms. Claybrook, you're recognized for 5 minutes.
Thank you so much, Chairman Rush, and thank you for your work on this bill. I am Joan Claybrook, and I'm President Emeritus of Public Citizen and a former administrator of NHTSA. And since I left office in 1981, 1 million people have died in auto crashes. And many, many more have suffered horrible injuries, many millions more. And the cost of the nation is about $6 trillion. So this is a huge issue. In the last 18 months, we have seen some huge regulatory failures in this country, whether it's been in the massive failure of regulation in the financial sector, whether it's been in the case of the Toyota Motor Company, whether it's been in the case of the 29 miners who have died because of violations in the mining industry, whether it's been because of the horrific oil rig explosion and the lack of regulation there. And the costs to the nation, to individual families, to small businesses have been unending and will continue for many years to come for all of these families that have been involved. I say these because these regulatory failures, this corporate malfeasance, this attitude of profits before safety, an extraordinary loss of life in auto crashes set the backdrop, it seems to me, for the discussion about the need for this bill. With strong regulation and enforcement, regulated companies take fewer risks with the public safety, environment, and money. And I strongly endorse your bill because I think that it will help to deal and address some of these issues. I do ask that my entire statement be included for the record, but I will summarize our particular concerns. First, I'd like to mention in Section 107 the event data recorders, which we believe need to be vastly improved from those now in practice. And there needs to be particularly a single uniform access tool for downloading them. Even, there's an issue whether the location should be recorded. If you call 911 on your cell phone, they have your location. So I don't see why that's an exception. And I believe that there needs to be an automatic transmission of the data that is collected in the EDR to a NHTSA database with privacy protections obviously taken into account. NHTSA's been excellent at having privacy protections for all the data that's ever used. This latter feature is important for the essential NHTSA data gathering, which is expensive and totally inadequate to date. The industry and we agree completely on improving the NAS system, but NHTSA needs real-time access to on-the-road information to conduct its research, rulemaking, and enforcement. It needs robust and statistically valuable data, and this can be accomplished as a part of the new EDR requirements. As to enforcement authority, I strongly support the new penalty provisions in the Imminent Hazard Authority, but I urge the inclusion of criminal penalties in this legislation. I know there's been some objection and resistance to having criminal penalties, but I would just like to point out that statutes covering motor carriers, hazardous materials, aircraft, oil pipeline, waterfront safety, railroad safety, clean water, food, drugs, cosmetics, solid waste, clean air, mine safety, occupational safety and health, consumer product safety and consumer product hazardous substances, securities, antitrust, and vehicular homicide all have criminal provisions in them. And I don't understand why anyone suggests that NHTSA should not as well. These prosecutions would have to go through the Justice Department, which has a very high standard for intent, and they would have to be knowing and willful. So I think that it ought to be included in this legislation. We support the transparency provisions in the legislation because they encourage and assist the public in reporting safety problems, and we support the judicial review for a public petition for a recall. The industry talks about wanting due process for itself. We want due process for consumers. Without the opportunity for oversight, the agency can ignore its obligations, and it indeed has in the past. It's unlikely that this provision would be used often, but because it's expensive to bring such suits, but it's important. And I do endorse adjustments to this section. In addition, clarifying that lawsuits in the transparency section, that lawsuits should be separately reported from vague claims of letters under early warning, that categories of defective elements of a vehicle should be vastly enlarged so the public knows what we're talking about, that we should make public reports that manufacturers have of deaths under early warning, and that collecting the names of and addresses of aftermarket tire purchasers should be included so that they can be notified about recalls, which they cannot be now. And to require NHTSA to fully document meetings with interested parties when they have them, which they haven't been doing. As to funding, we think the agency is starving to death. The whole budget is $132 million. It needs to be vastly increased. And it should be $500 million a year. And so we hope that that will happen under your jurisdiction. And finally, I do have in my statement, I won't mention them specifically, but I think there are three things that are included for the integrity of the agency, and that is not having a facility that's owned by an auto manufacturer, having whistleblower protection, and having revolving door protection. Thank you very much, Mr. Chairman.
Thank you very much. The chair now recognizes Mr. Ditlow for 5 minutes.
Thank you, Mr. Chairman, members of the committee. I'm Clarence Ditlow, Executive Director of the Center for Auto Safety, a small group that has watchdogged the National Highway Traffic Safety Administration for 40 years now. We deeply appreciate the effort that went into drafting the proposed Motor Vehicle Safety Act of 2010, and both consumers and auto companies alike will benefit from fundamental reforms to the National Traffic and Motor Vehicle Safety Act. And indeed, when you look at NHTSA, it's a wonderful agency. It has a vital mission, but it is woefully underfunded, woefully understaffed, and outgunned by the industry it regulates. To expect today's NHTSA to adequately regulate the trillion-dollar auto industry is like asking a high school basketball team to beat the LA Lakers. Unlike other public health and safety agencies, NHTSA doesn't even have its own research facility. Instead, it must rent space at a facility owned by Honda. Now, when we go back and look at the original agency, it was much better equipped to handle regulating the auto industry than today's agency. Today, there are twice as many vehicles, there are twice as many motor vehicle manufacturers, and the motor vehicles themselves are probably 4 times as complex as the motor vehicles that were on the roads in the 1960s and 70s when the agency was formed. The original agency had a research program that did things like research on advanced airbags, a research safety vehicle. It did more research on electronic controls in vehicles in the 70s than it did in the 80s or 90s. That budget, those resources, they led to advanced safety standards, like the airbag standard. And the auto industry went from a company that couldn't dislike airbags more than to an industry that today they want to sell as many cars as they can with airbags and use those airbags to promote the sale of motor vehicles. It's an example. Safety does sell. What has happened, though, is that the safety system at the agency is significantly broken down. If we look just at the defects and recalls division, it used to be that the whole process was open. You could go in and look at citizen complaints. You could go in and look at warranty data. You could look at the files and rebut what the manufacturers were saying. Recalls and investigations took place in a much shorter period of time. We had the General Motors sudden acceleration problem due to failing engine mounts. from the time the investigation was opened to 6.7 million vehicles were recalled was less than a year. GM didn't suffer in sales like Toyota did. And today what we have is investigations that go on forever almost. And we have multiple recalls. The consumer is dismayed. The manufacturer loses sales. And when we look at the early warning system has actually made the investigatory process worse. Things that used to be public are not public anymore. You can't tell how many deaths and injuries that there are on Toyotas. There were 301 death and injury summary reports filed to NHTSA, but only 15 were requested. All death reports should be made public. I've concentrated primarily on some of the openness and transparency. I want to say to Mr. McCurdy, in the history of the agency, we had 23 years when there was judicial review of agency decisions on defects. And in 23 years, there were only 2 court challenges, scarcely a burden. And what you will find is there won't, it's a check and balance that's needed. When we go forward with the rulemakings under this, we're going to have a situation where we're correcting the catch-up. Where the agency is behind. The agency needs more research, more funds. Just looking at the accident investigations alone, there's only $15 million. We need $60 million for accident investigations in this country, and they can catch defects like Toyota. So when I look forward to the future, this legislation provides a unique opportunity to not only reduce the unacceptable tolls of deaths and injuries in the nation's roads, but also to provide stability to the auto industry, which suffers from lack of public confidence in sales when preventable defects such as Toyota's sudden acceleration occur. The federal government through NHTSA should lead the way to vehicle safety, not come on after the fact and try to clean up a mess. So I thank you for your time.
The chair now recognizes Mr. Harper. Mr. Harper, you're recognized for 5 minutes.
Thank you, Mr. Chairman, Ranking Member Whitfield, and members of the committee. I'm very pleased to be here. My name is Jim Harper. I'm Director of Information Policy Studies at the Cato Institute. I'm delighted for the opportunity to testify about the Motor Vehicle Safety Act draft, and particularly Section 107. Until a decade ago when I left the Hill, I was a Judiciary Committee guy. I hope you won't hold that against me. I do believe maybe the substance of my testimony will be what you hold against me. But before I turn to the...
We'll try not to hold that against you.
I appreciate that. Before we turn to the privacy issues at play with EDRs, I'll make two observations that are really straight out of the Skunk at the Garden Party file. Across the country today, Americans are rereading the Constitution, and they're trying to square what it says with the activities of Congress. I fully acknowledge the good intentions, of course, of everybody involved in auto safety issues, but I have a hard time finding that to be a federal government responsibility. The Constitution's grant of authority in the Commerce Clause was aimed at making commerce among states regular, ending the trade wars that had broken out among states in the Articles of Confederation. Framers did not intend for the Congress to regulate the quality and caliber of goods and services traded in the United States. My quick study, necessarily quick study of the economics of Section 107 dealing with EDRs draws me to doubt whether installing event data recorders in all cars sold in the United States is a cost-effective auto safety measure. Driving the cost of new cars higher raises the cost of used cars because it limits the market of used cars as people don't trade up. Under the, I think, entirely plausible assumption that newer cars are safer than older ones, raising the prices of cars with EDR technology keeps poorer people in older, less safe cars. Now, of course, that's not to say that analyzing data is a mistake. Good data will improve auto safety, but almost certainly sampling auto crash data using EDRs in a cross-section of cars would provide safety benefits without the costs of mandating EDRs for all cars sold in the United States. My analysis of the economics is worth the money you're paying for it, of course, but I want to highlight that there are trade-offs here, and it would be regrettable if large societal investments in EDRs and EDR data drove up costs and kept the country's poorer drivers from trading up, endangering their lives for the benefit of the wealthy drivers who buy new cars. I'll turn to privacy, and there's no issue more complicated than privacy, of course. Privacy in its strongest sense, the word privacy means the ability to control information about oneself. I believe the protections for EDR data stated in Section 107 may help clarify the privacy issues around EDR data and so provide a small benefit in terms of privacy protection. But control also comes from having a say in the information infrastructure around you, in what data collection happens in your car, in your home, when you use your computer, and so on. Consumers today have no control and little awareness of EDRs in their cars. They can't control the presence of EDRs or their functioning. There are shades, unfortunately, in Section 107 of too little too late in terms of protecting consumer privacy. Consumers should have a say in the first instance of whether data is collected. Society-wide data collection and use will continue to grow in our society. Down the road, the capacity of EDRs will grow, undoubtedly. EDR data will integrate with other data collected and used by the automobile, and EDR data will regularly be used in litigation and for many other purposes. Your car is a computer, but if you have almost no control of what that computer does, your privacy is very much threatened. Think of EDRs in the near future as an ankle bracelet that all drivers will have to wear just for getting behind the wheel. We're talking about a loss of privacy and autonomy in developing this kind of data infrastructure without consumer input or control. Without doubt, there's no doubt in my mind, of course, everyone is trying to do the best for auto safety and consumer welfare overall. But consumer welfare involves the freedom to live as you want unmonitored. Now, I'll brag slightly that I rebuilt a few engines when I was in high school. I'm proud to report both of them ran when I was done with the process. There's no reason on God's green earth why a 429 4-barrel and a 1973 Mercury Montego should have a double roller timing chain, but mine did, and I was proud of it. I miss the day, frankly, when people could tinker with their cars, make their cars an expression of themselves. It may be computer geeks in the future that want to tinker with their cars, and with the data and computing power in their vehicles, make those cars something special. But I think that freedom, consistent with safety, should continue to exist. Thank you very much for hearing me out.
That concludes the opening statements of the witnesses. And I have a question that I want to ask all the witnesses to respond, if you will. A lot of ink has flowed on this topic of automobile safety. There's been additionally several informative oversight hearings held in light of the Toyota incident. And we've all come to the conclusion that NHTSA needs to be recalibrated. It needs to be remade. We need a new model for NHTSA, an upgraded model for NHTSA. It needs to be energized. It needs to be equipped to achieve its primary goal of securing public safety on the highways. And I just have a question, a general question for each and every one of you. In an immediate sense, in a nutshell, what is the best possible piece of legislation that you would envision? In other words, what, in your words, in your viewpoints, what is the provisions that must exist in any kind of refurbishing of NHTSA, and what provisions must not exist? Each one of you, would you? All right, David wants me to start with you, Mr. Harper. Would you please be so kind?
I'm not a NHTSA expert, and I apologize for that. But I think two laws that are very important in this area that relate to some of what I've said are the Regulatory Flexibility Act, which requires economic analysis of major rules having a consequence of more than $100 million. And I think the analysis should include what the potential costs of all mandates in the bill are, regulatory mandates, so that we can understand that if car prices are rising so high that it prevents a used car market from emerging. You know, there are kids today driving around in cars from the 70s, and when they get in an accident, those cars are more likely to get in accidents because of design, age and design flaws from the past. When they're in accidents, they're likely to get suffer more injuries just because newer cars have better safety features in them. So we've got to consider getting people out of older cars into newer cars, and that's done by making sure that cars are relatively inexpensive. So there are trade-offs here. The Reg Flex Act would be involved in that. Another is the Government Performance and Results Act. The Results Act was just getting started when I was on the Hill, and I recall NHTSA being an example of an agency that did a pretty good job of measuring results per dollar. It's a lot easier than rating components of the Justice Department where you're trying to measure justice in terms of per dollar. You can't do it, but traffic statistics you can do per dollar, and I think continuing that would be important.
Yeah. Mr. Nillo, do you have any concise comment?
Mr. Chairman, I think that the transparency and oversight provisions are the most important, because you can, when you look at issuing new standards, we need them. There's no question about it. But I'm looking at the past 40 years of this agency, and there needs to be a public oversight to hold the agency accountable to enforce the laws that are there. And unfortunately, we don't have the access today that we once had. So creating the transparency of how the agency functions, the data that should be public but is not public, and then the right to judicially challenge the decisions of the agency. That's what will make the agency work for the future. It's the age-old story. You can tell the agency to do something, but how do you tell them to do a good job? It's the citizen that's going to make the agency do a good job.
Thank you. Ms. Claybrook, I can't wait for your answer.
Thank you so much, Mr. Chairman, for asking the question. I would say that the resources for the agency are totally essential, that this agency is starving to death, as I mentioned. $132 million is ridiculous to expect it to do its job. And so I think that this bill should not be passed without a goal of $500 million a year annual budget for the agency in the next 4 years. So I would say an increase each year of $100 million on top of the prior year. That's the only way this agency is going to have the capacity to do the job that you and I expect it to do. What it shouldn't have, in my view, is a situation where it has conflicts of interest. I think that it should not have a test facility owned by a manufacturer. I think it's a terrible conflict of interest. So that's something that's not in the bill. I think it should be added to the bill. I think that there should be criminal penalties.
Thank you. Mr. Stanton?
Yeah, thank you for the question. Thank you for the question. I think I've been in the industry almost as long as most of the people up here, maybe not quite as long, but I remember very vividly years ago when seatbelt use was 12%, and now we're up to over 90%. So we've made tremendous progress in this whole area. And cars have gotten so much more complicated over the last 30 years. And we have argued and have lobbied, not as successfully as I would like to say, for additional funds for NHTSA when it comes to NAS, the NAS system, and the FAR system. NHTSA needs to be a data-driven organization, and to the degree that we can get them a greater amount of better data, the better off we all are going to be. And then the final point is that the rulemakings that NHTSA undertakes, they really have to be an open process, and they really cannot have the final rule in sight when you start the process. You're not being data-driven if you do that. So the degree that they can go through the rulemaking process, have it open, have the record dictate what the final rule looks like, and when it ought to be implemented, given into consideration the implementation schedules required by automobile manufacturers, we end up with a better product.
Mr. McCurdy, you want to answer this? Okay.
Oh, yeah, yes, Mr. Chairman. I wasn't completely deferring. I was just suggesting an order here.
My time is
Mr. Chairman, the rule of thumb I've always used on legislation is if you've had hearings and you identified a problem, then address the problem very clearly and simply. And we made some recommendations in our testimony of those areas that address the particular problem that this committee in Congress has identified. We're not into relitigating and going back decisions on judicial review that was made in 1988 by courts. What we'd like to do is work with you to see how we can make this a bipartisan approach that uses common sense to really address the underlying problems. And I think you have the basis there. Again, there are some key elements that some rulemakings at NHTSA. And my last comment on this, I do not believe that NHTSA is broken. You know, you used a car metaphor when you talked about a new model. It takes about 5 to 7 years for the industry to create a new drivetrain or a new model. You don't need to go through that. I think there are some tweaks here that you can address, and I think and we agree that it needs to be adequately resourced. The center is a good idea. There's some very important studies that are going to take place that we are anxious to see what those results are, which provide data. The National Academy of Sciences and even NASA's recommendations, I think, will have a real impact and will help this committee do its work as well.
Thank you. The chair now recognizes the gentleman from Kentucky for 5 minutes.
Thank you all for your testimony. In reading your testimony and also in your verbal response to questions, there has been a number of references to these studies that are ongoing by NASA and by the National Academy of Sciences. Are those ongoing because of a contract with NHTSA, or are these being conducted by contracts with the automobile manufacturers?
It's through NHTSA, and it came about as a requirement from the Toyota investigations and the need for additional knowledge, and DOT then contracted with NAS and NASA.
Because as someone who really doesn't understand cars, it seems like this pedal placement standard and transmission configuration standard, when you think about the vast variety of vehicles, it would be difficult to come up with a uniform standard very quickly. And I think that the administrator of NHTSA indicated that he did not think that they could meet the time frames in here. Do you all, how many of you believe that NHTSA could meet the time frames for the regulations called for in this legislation?
Well, as my colleague mentioned, there were 9 mandates and different rulemakings, and we believe, and the administrator admitted that this was too compressed. Yeah. Again, I don't think you have to have that many rulemakings. I don't think you have to. Those will not address the problem that really was with Toyota. Brake override will address that. It's preferable to pedal placement or the other approach, which, again, there was a certain overreach in the drafting. And I understand positional negotiation, and obviously the administrator was asked the question, what all would you like to see in this bill, or did it cover? And he said, it captures the universe. Right. Well, it really does capture the universe. Right. It's very broad. I think you need to narrow it now. And in order to get those real problems addressed, I think a very straightforward rulemaking on 1 or 2 items can address it.
Ms. Claybrook, what do you think? Do you think that NHTSA can meet these deadlines?
Well, they're certainly going to need a lot more resources in order to do so. I would say that. I think they're very tough deadlines. I think that they are important, though. I don't believe that the brake override solves the problem. The brake override is like a safety protection if you have a problem, but it doesn't solve the problem. What you need to solve the problem is to change the electronics and improve the electronics in the vehicles themselves. And so I think that these standards are really important for the agency to address. The reason they have deadlines in them is because the agency has taken years and years and years in the past to do its job. And so there's a lot of frustration with that and with the endangerment of the public that occurs when they don't act.
I personally, yes, Mr.
Just real quickly, there is already a standard FMVSS on the transmission, and it has to be intuitively correct, so there's some work that has already been done on that. But I don't think that there's any way in the world that you could anticipate what the requirements are going to be, what the rulemaking outcome should be. Take, for example, your gas pedal and brake interface. What does that mean? How are they going to deal with that? Are they going to move the brake pedal further away from the gasoline pedal? And then what's the implication of that on safety? And what does it mean to the floor plan of the vehicle? And then how do you do that in 2 years? That's not good government.
Do you have those concerns, Mr. Harper?
I do. If you look at some of these, there's a great deal of information the agency already has. There was a year-long study done through the Volpe Center on the brake pedal placement. There's certain recommendations that they've made. And then when you look at all 9 standards, there is a provision for the agency that if they can't meet the deadlines to come back to the Hill and inform the Hill of that. And that happened with the roof crush standard that was issued last year, and we got a much better standard out of it.
Thank you. Mr. Harper, you want to comment? Okay. Let me ask one other question. I see my time is about to run out. The judicial review for a defect petition rejection and trying to stay an imminent hazard order, the judicial reviews are different. In one, you go to a U.S. District Court, and the other, you go to the U.S. Court of Appeals. Does the fact that these judicial review procedures are different, is that of concern to any of you?
I would say that the way that they're handled is problematic in both cases for different reasons. Certainly the judicial review on imminent hazard is a deviation from what is under the CPSC and the other area where the agency would have to go to court to get the teeth and the ability to do it. But the judicial review on the other side is for both defects, rejections, and also for new standards. And we're concerned that you could have a lot of people that would like to see a new standard that NHTSA would really not, for good reason, not want to promulgate, and yet they have now the ability to go to court, and we think it ties up the agency, will tie up the lawyers, and not get the job done.
Thank you, Mr. Chairman.
If I could just comment on that. I would just comment not on the need for them, but on just the procedure, which is that I think under the imminent hazard provision, you would have to have some kind of a mandatory agency hearing of some sort, so that there'd be a record before they would go to the Court of Appeals. So I just comment on that. Yes.
Yeah, and the provision for review of a defect petition is limited to that defect petition. We had 23 years of experience where there was judicial review until the court in 1988 said there was no law to apply, and yet we only had 2 lawsuits. And one of those lawsuits actually resulted in the Kelsey-Hayes landmark decision, where instead of recalling 50,000 GM pickups with a camper body, they recalled 200,000 because all of the wheels on any of the GM pickups could fail. So it's worked, and what we'd like to do is just reinstate it.
Mr. Braley, you're recognized for 5 minutes.
Thank you, Mr. Chairman. Mr. Harper, I took note of your testimony talking about people who are foregoing new car purchases, remaining in older cars, which in many cases are more hazardous to operate on the roadways of this country, and the effect of that in terms of greater morbidity and mortality. You know, this came up during the Cash for Clunkers debate because, as one of the original co-sponsors of that bill, a lot of us felt like we could have done more in terms of giving incentives for people to get older cars, used cars off the road, and replacing them with higher quality used cars in addition to new cars. And one of the things that Consumer Reports mentioned was that a benefit that few people talk about from that Cash for Clunkers program was a dramatic improvement in vehicle safety from those older cars that were being taken off the road and replaced with some that had some of the safety components that Mr. McCurdy referred to in his opening statement, that consumers are benefiting from a range of innovative new safety technologies. So I think one of the things we have to be doing as we set policy outside the scope of NHTSA is also looking at ways to provide incentives to people who, because of their economic circumstances, are stuck in these older vehicles. We see this in the real-world environment, and I think that's something that goes beyond partisan politics and gets to the root cause of how we provide people with a better occupant compartment. But I would like Ms. Claybrook to comment on the privacy concerns that Mr. Harper raised, because my understanding of privacy is that it goes to an expectation of privacy, that in order to have a basic right to assert a claim based on privacy, you have to have an expectation in that time, manner, and place that there is a privacy concern to protect. In order to be in one of these vehicles with an EDR device in it, you have to be licensed and given the privilege of operating a motor vehicle. So I'd like you to respond, because in one of the points you raised, you talked about the necessity for mandating recording of these incidents, and I would like you to respond to that.
Well, I can tell you that NHTSA has incredible privacy protections built into all of its operations, and particularly for any investigation that it's done of any crash. They've been doing this for 45 years, and as far as I know, there has never been any disclosure in all that time of the thousands and thousands of crashes that they've investigated of any problem. And that's not something that necessarily people would even have an expectation about, because they don't necessarily know that their crash is going to be investigated. With regard to EDRs, every consumer should have in the owner's manual, and I believe even more prominently in the vehicle when they buy it, an indication that they have an EDR so that they know they have one, that they have the right to have that information. They own that information, in fact. What I have suggested in addition is that there be an electronic transmission of just the data, not the private information of who owns the car or the name of anybody, to the agency so that it can have real-time data to do its job. And this is where Mr. Stanton and I completely agree. We think that the agency needs much more data, and if we can send a satellite up and we can download data from that satellite, or if we can send people to the moon and talk to them from NASA while they're up there, it seems to me we can download data from an EDR. And so the technology is certainly available. It's just a matter of the will to do it, and to do it in a way that does not harm any person.
Well, and that goes to one of your related recommendations, in that in the third item you mentioned was that that the access tools be commercially available, which is a current standard, that we have to have a uniform system for recording and extrapolating the information. This is the same problem we face, by the way, with electronic healthcare records, and the problem we're having with the ability to share information that can help us transform the way we learn from healthcare that's being delivered in this country. One of the other questions I wanted to ask you about has to do with the the reporting of lawsuits as part of the early warning system, which is not currently required. The reason I don't understand why that was not part of the original requirement is, if you look at the parallel problem of reporting incidents of preventable medical errors under the National Practitioners Database, they are required to report both claims that are reported under any system as well as lawsuits that are filed, and that's part of a comprehensive effort to improve patient safety. Wouldn't that same logic apply in this setting?
Oh, absolutely. And in fact, we asked the agency to include a separate listing of when lawsuits are filed, because if someone just writes a letter to an auto company and says, well, I'm thinking about, making a claim against you because I've been harmed from a defect in your vehicle, it's an entirely different thing than if a lawsuit's actually been filed. And because these lawsuits are complicated, difficult, expensive, and people don't file them unless they have a real in view that they could win these lawsuits, because they're taken on a contingent fee basis by the lawyer, who doesn't want to have to end up paying a lot of money to do it and then not winning the lawsuit. It's entirely different in terms of the seriousness of that issue. And so I think that separately reported from just claims ought to be lawsuits filed on any particular make, model, alleged defect that's reported under the early warning system. And that it's just a number of lawsuits. It's not anything else. It's just a number. And so the consumer knows when they go on the database, they could look and see, here's my make, model, there's alleged defect, that's the same problem I had. And by the way, there are 2 lawsuits that have been filed, or there are 20 lawsuits that have been filed, whatever it may be. That's going to inform them a lot more about the seriousness of this issue than just that there's a bunch of claims that have been perhaps discussed.
Thank you. I yield back the balance of my time.
The chair thanks the gentleman. The chair thanks all the witnesses. There's a vote occurring on the floor. So with that said, we're going to adjourn the panel, and thank you again for your time that you have invested in this hearing and in this legislation. Thank you so very much. The committee now stands adjourned.